Hello students, my name is Nayan Kohli, Assistant Professor, Mahatma Phule Arts Science Commerce College, Panvel. In this video, I'm going to discuss about Indian Contract Act 1872, some part of Indian Contract Act. First, we will see the definition of a contract. So, as per Indian Contract Act 1872, contract has been defined as an agreement enforceable by law, that is a contract. Okay, so there are two terms. Okay, one is agreement, and it must be an agreement, and that must be enforceable by law. So agreement has its own definition. So agreement says that every promise or set of promises forming consideration for each other is an agreement. Okay, so in this there must be a promise from the parties with each other, and there must be a consideration from the each other. What does it means? Consideration means something in written. So we have a classic example of a rent agreement, right, where the tenant who wants to avail or get the house property on rent, he approaches the landlord. Okay, in this case landlord allows him or handovers the keys to use his property, and in that agreement they sign the agreement between those two parties, and in that agreement that person or tenant pays the money to the landlord. That is his consideration in this agreement, and landlord handovers his keys of the house property to use it on rent to the tenant. So that is the consideration from the landlord. So this is the consideration between the parties, which you know finally signs the agreement between the parties. So that is the agreement. And what is enforceable by law? Enforceable by law means simply means which is applicable legally or acceptable legally. Okay, so enforceability comes if in this enforceability what is lawful or enforceable by law and what is not enforceable by law. In this case, with this example we can understand what is enforceable by law, what is not enforceable by law. So there are two parties, there are two persons wants to deal with each other. Here in this case this person ask him to kidnap one person for him. So that is something illegal, right? Unlawful. Okay, or if he ask him to kill somebody for him, that is again, that is illegal, or supply him the drugs. Okay, so these are the examples of unenforceable acts, right? In this case that is not a contract. So forming a contract or forming a legal contract, there must be an agreement, and that must be enforceable by law. Okay, so there are certain essentials of contract. So what are the essentials? Essentials means something which is really very important, vital for forming a legal contract. So there must be two parties. That is the first essential of a contract. There must be two parties to a contract, and those two parties are termed as offerer or promiser and offeree or promisee. Offerer or promiser means a person who offers someone, okay, about a contract, and offeree means or promisee means to whom the offer is made. Okay, so these two parties required for a forming a legal contract. Okay, one single person cannot enter into a contract with himself or herself. That is a basic or logical thing in a contract, right? Now the second point is offer and acceptance. There must be a proper offer and legal or lawful offer and lawful acceptance between the parties. When the offer is made and that is been accepted by the person, then those two persons comes into a contract or signs a contract. So that is the offer must be lawful, as I said, that must be absolute and not conditional. The offer supposed to be absolute, not a conditional, and lawful acceptance supposed to be there from the another party. After that, third point is agreement must be enforceable by law. That point I have already explained, that something which is not legal, something which is not unlawful, that cannot form a enforceable, that cannot be enforceable by law. So that is the each and every agreement supposed to be enforceable by law to form a legal contract, right? Now, the fourth point is consensus ad idem or identity of mind. What does it mean? Consensus ad idem means meeting of minds in a same way, in a same manner, and on a same thing. Okay. With this example, we can understand what is consensus ad idem. There are two parties. One name is Rahul and one name is Akshay. Okay. They are Rahul has two cars basically. As you can see in the picture, this one is sports car, this one is a normal car, and he wants to sell one of his car. And in his mind, he was offering about this car. Okay, so this car obviously having a lesser amount or less expensive than this one because it is a of course it is a sport car. It might having a huge amount in so he was basically offering him about or proposing him about this car, okay, normal car, and he was offering him for a 5 lakhs. But this person thinks that he was offering him the sports car, which is obviously an expensive car, and if he is offering him on a 5 lakhs, that means it's a good deal. So there is no meeting of a minds. They are not, in the in a in a position where the terms and conditions are absolutely understanding in a same way on a same manner. So that is not a consensus ad idem between the parties, and which will not lead to a formal legal contract between the parties. Now, the fifth point is consideration for essential of a contract. Consideration must be there. Consideration from the both the parties, as I said, that it is consideration means something in written. As I said, as we seen this example before also. Okay, so this is the consideration. Whatever tenant is paying as a rent, that is the consideration from the tenant, and whatever that landlord allowing him to use his house property for a rent, that is the consideration from the landlord. Okay, and the consideration can be in cash as the tenant is paying a cash, right? It can be in a kind as house property been let out to the tenant for use on rent, so that is the kind consideration. Then it can be in an act, okay, something doing something, that is also can be a form of a consideration. And forbearance, not to do something. Forbearance means not to do something, that is can also be a consideration. Okay, and the consideration must be lawful. That is the major part of a that point. Consideration must be lawful, that must not be unlawful. Okay, now after this, the sixth point is capacity of a parties who are entering into a contract. Means as per the Indian Contract Act, the capacity of a person defines with the age, right? First of all, he must be of a major age, right? Major in means what? When a person attains his age of 18 or above 18, that person is considered as a major person, right? And below 18 years old, he is the minor person. So person entering into a contract as per the Indian Contract Act, he must be a major person, not a minor person. Okay, that is the first capacity, right? And the person supposed to be sound minded. Okay, if a person is of unsound mind, he cannot enter into a contract. Okay, and thirdly, he must not be disqualified by a law entering into a contract. That is the capacity of entering into a contract. He must be a sound minded, he must be a major, and he must not be disqualified under any law. Then seventh point is free consent. The consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. These are the points. When it is not caused by these 5 points, then it is the consent is said to be free. Okay, coercion means if somebody is uh, you know um, taking the another person with forcefully in a contract,
that is the coercion. Undue influence means having a wrong influence over the other person. So that is the undue influence. Fraud you means deceiving someone. That is the fraud. Misrepresentation and mistake, that is also the part of it. Misrepresenting something and taking that person into a contract, that is also illegal. After that, 8 point is lawful object. The object of the contract supposed to be lawful. It's supposed to be legal. If the object of a contract or object of the agreement is not lawful, then it cannot form a legal contract. 9 point is agreement must not be declared to be void. Void means not useful or unuseful things. Okay, so there are certain examples of it. Agreement who are declared to be void, that is agreement in restraint of marriage. If somebody is restraining or restricting someone by of marrying somebody of his wish, so that is the agreement in restraint of marriage. Second is agreement in restraint of trade. As a citizen of India, all the person have the right to do business or trade in any part of a country. Okay, so that is his right. If somebody is restricting someone by doing trade or doing business in some part of country, then that is the agreement in restraint of trade, which will be treated as a void agreement. Okay, which is of no use, which is of no meaning. Then agreement in restraint of judicial proceedings. If somebody is restricting or interfering wrongly in the judicial proceeding of our country, that is also a void agreement. And agreement of wager means betting and to do something which is impossible things, that is the agreement which is declared as a void. Okay, and last point is legal formalities. Okay, so to form a legal contract, each and every person supposed to follow the legal formalities. Legal formalities means forming a proper documentation, completing all the formalities, legal formalities like registration, stamping, attestation, stamp paper, and etc. So that is the essentials of a contract, without which a legal contract cannot be formed. To form a legal contract, these 10 points supposed to be there. So that is the essentials. Thank you so much.